The judiciary is the guardian of our constitution, and it is a great honor for us to have one of its distinguished custodians in our midst today. It's time for our today's chief guest, Sri Honorable Justice G. Ramakrishna Prasad Garu from High Court of Andhra Pradesh, Amaravathi, to grace us with his address. I request Ms. Nandita from 3rd year BBA LLB to give the audience brief introduction about Sir.
He represented major institutions including APSRTC, GHMC, Andhra University, ANU, NIMS, SV University, and served as special standing counsel for the government of Nagaland and as the counsel for the Rajya Sabha Secretariat and Rajya Sabha TE. A landmark case, he argued intellectuals from Tirupati vs. State of Andhra Pradesh. He is now part of the environmental law syllabus at Faculty of Law, Delhi University. Your Lordship, your presence here is source of great inspiration, and we are eager to hear your insights on this monumental occasion. My Lordship, you have the floor.
Senior Brother Justice S.Chandra Garu, Rector Sivaram Prasad, the Registrar of the University, my friend and Senior Advocate Mr. Prasad Venkateshwar Garu, other Professor Vijay Lakshmi Garu, other dignitaries on the dais, off the dais. Good morning to you all, friends. Today, this pleasant morning on 26th November, we all have gathered here to celebrate one event, that is the Constitutional Day. It has a significance and it has a purpose. More than the significance, it has a purpose. As the generations pass by, since 1946 onwards, the next generation slowly tend to forget the sacrifices which have been done by our freedom fighters for a very, very long time. 15th August 1947 was the day on which India celebrated independence. Two nations were born, Pakistan and India. Then thereafter, we have drafted the Constitution for ourselves. Now, what went into the drafting of the Constitution is one which becomes very essential for not just the law students, the lawyers and the judges to know, but for every citizen of this country. Honorable Vice Chancellor was just saying that it is a holy book. It is a holy book for the whole nation. While different faiths may have different holy books, but one single holy book is that book that drives this entire nation, that governs this entire nation, and that is the Constitution of India. Now, several countries have got constitutions drafted. Now, when these constitutions are drafted, it is its own very special document for that particular country. They say that constitution is a political contrivance, which means at the time of drafting of the constitution, all the kind of sufferings which the people of that country had gone through, and then the solutions which are supposed to be propounded are all incorporated into the Constitution. Now, if you see the oldest Constitution that is there of the United States of America, drafted in 1758 and so on and so forth. Now, for almost 200 years, the Constitution, that small text, has worked out itself very beautifully. 1946, August 1946 was the time when, for the first time, the Constituent Assembly was formed. But that was still under the control of the British Raj. After the Government of India Act 1947 came to be enacted, the control of the British Raj came to lapse completely. And thereafter, the Constituent Assembly has become independent, not being answerable to the British. And thereafter, it was Justice Rajendra Prasad who was elected as the permanent chairman of the Constituent Assembly. The work began in 1946. Thereafter, effectively from August 18th, 1947, the Constituent Assembly has begun its sittings. 2 years, 11 months and 18 days is the time that it took for our constitutional framers to dissect every bit of the social life of every individual in this country and then incorporate those necessary provisions to drive this nation for the future. That's the reason why they say Constitution is not just the text in black and white. It is a living document. The founding fathers have always taken care to see to it that the Constitution would be a living text, would be an organic document which will drive and take forward the generations from time to time, which means that this document has got the ability to amend itself to suit the necessities of that current society. This is one of the very great feature of this Constitution, our Constitution and perhaps many other constitutions as well. It is said that the Constitution framers would not want to rule this nation from their graves, which means that they do not want the country to be run with their own antiquated ideas, in the sense that as what they have conceived at that point of time, that situation may not be prevailing much down the lane, and therefore the Constitution should be able to amend itself and serve to the needs of the society for all generations to come. So that is the manner in which our Constitution has been drafted. Now, if you look at the functioning of the other democracies, particularly the other nation that took birth on 15th August 1947, Pakistan, they also have a constitution. Country went into upheavals, military rule for 39 years out of almost 78 years. So while this is the plight of Pakistan, our neighbor, India, we have respected the Constitution, and the Constitution has come to stay without any change. Minor amendments are of course permissible, and they have been done depending on the necessity of the hour, but then the Constitution has come to stay. It is working very well. We never had any kind of a military rule or anything. Perhaps one abuse I can say that was attempted against the Constitution was in 1975 during Mrs. Gandhi's regime, when emergency was imposed, fundamental rights suspended. Article 368 has also been amended, and in such a manner, but then the citizens of this country who have been conscious, who knew the importance of the Constitution and their duties, have fought back. The whole thing was reversed by the 44th Amendment. All that what Mrs. Gandhi has done by the 42nd Amendment was all reversed. So that is, except that one dark period for the Constitution of India is rather very robust today. Dr. Ambedkar, while drafting, at the time when he was the chairman of the drafting committee, lot of discussions were going on. The Constituent Assembly was divided into subcommittees, several committees and subcommittees, and each of the subcommittee and committee has worked on one branch of the Constitution. Then all the reports prepared by the subcommittees were put together, and then a broad draft Constitution has been introduced in 1948, published, and had given almost 6 to 8 months for the citizens of this country to go through the document and react and come out with their own opinion or ideas, or any criticism also for that matter. So it was during one of these debates Baba Saheb Ambedkar has said this, that this is only a text as it looks. Its ability to work is entirely dependent on the people of this country. The people of this country would, if they respect the constitution, then it is only by this way that this document can be preserved. Now the document, just Professor Vijayalakshmi was also mentioning that it is the supreme law of the land. So what does it mean? What is the significance of saying it is the supreme law of the land? We have other statutes also. In the jurisprudential context, it is called as the Grand Norm, which again is the supreme law of the land, suprema lex. Above the President of India, above the Chief Justice of India, above the Supreme Court, above the legislature, the parliament and the state legislatures, this document stands high up. All these institutions derive their powers and functions and duties out of this document. This is the significance of this document. Now we have seen for 75 years, we have seen the march of the Constitution. While our neighbor is still reeling under a doubt whether their constitution is still workable or not, we have gone ahead miles, perhaps thousands of miles ahead. We reached the moon technologically. If that is made possible, it is only because all the organs of the state are working within their respective spheres. So it is the constitution that controls the three limbs of the state, the constitution that defines their powers and functions and says that this is your limit, you cannot go beyond it. Every organ of the state has its limitations. Now the constitution has been drafted in such a way that even if the supreme majority of the parliament wants to do away with the constitution, repeal the constitution, it cannot. The fundamental rights which are there, even if the bull strength of the majority of the parliament, if they want to amend by curtailing or to whittle down the spirit of the fundamental rights, it cannot do so. Next mile step, as I said that our constitution is so robust and we are marching ahead. The next milestone that we have is in Keshwananda Bharati's case. As I keep saying even in my other lectures also, that if I am asked to mention one event which is as equal and as powerful as the constitution itself, that is the verdict that is given by the Supreme Court in Keshwananda Bharati's case. There the issue was, what is the power of the parliament to amend the constitution? Are there any limitations? Or the parliament has got absolute power to amend any part of the constitution in whatever manner it chooses? Argument of the Attorney General at that point of time was that short of repealing the constitution, Parliament has got the power to amend any part of the constitution in the manner it chooses. Now it was the great creative work of Mr. Nani Falkiwala, who was representing on the opposite side, who has propounded this theory of basic structure. When it comes to speaking about the limitations on the constitutional amendments, he said that Parliament has got the power, no doubt, but that power to amend the constitution is only limited to amending any part without affecting or without destroying its basic structure. Basic structure means any skeletal structure, like in a human body, our bone structure is the one that makes us, that keeps us in a particular shape. So if the bone structure collapses, then the whole thing will collapse. So therefore, what he said was that basic structure is that bone framework. If that framework is collapsed, then the whole thing will collapse. So you can amend anything without altering the basic bone framework which is there in the constitution. So therefore, naturally it came that there are implied limitations. The constitution does not speak of limitations on the parliament to amend, but yet there are implied limitations, unwritten limitations on the parliament to amend the constitution. So with this, then it became the duty of the Supreme Court to name as what is the basic structure, what concepts constitute basic structure. Now, you law students also, you would have read that the basic structure as what was propounded, it is not just limited. The constitutional benches of the Supreme Court have been further expanding the basic structure and say that these are parts of the basic structure which you cannot touch. So this is another great milestone that we went ahead. No other constitution and no other judiciary of any country could propound this ingenious theory which came to stay, and it has rather preserved the existence of the constitution forever. So this is the significance of this particular aspect. So today, 76th year of the drafting of the constitution, and after adopting the constitution, as madam was just saying, on 26th November 1949 our constitution was adopted, but immediately only few articles came into effect immediately then itself on 26th November 1949, and the whole of the balance of the constitutional provisions came into effect on 26th January 1950. You all know that. We all celebrate our Republic Day on that day. So these are the significant aspects which not only, it is not just significant for the law students and lawyers as I said, but it is the most significant thing for every citizen of this country to know, and again every year on this day to commemorate. Commemorate means to think of all the sacrifices once again, to remind ourselves our duties towards the nation and in respecting the constitution. The generations as they pass by, it is a duty of every generation to see to it that the principles in the constitution are well preserved. So as the duty is there in our hands today, tomorrow that duty will be transferred to you all. So you have to be conscious of the rulers and see to it that you have to fight against the rulers in case if the provisions of the constitution are being whittled down. So this is the kind of responsibility that rests upon you, and every year on 26th November this is what we have to remind ourselves about our own duties. I've been a student on this campus. I finished my LLM in 1992. My esteemed professors, Professor Vijayanarayan Reddy, Haragopal Reddy, and Professor Rangaya, it is under their guidance that whatever bit of law that we have learned. As Temple of Education here, now for some time the law department was actually wound up, and thereafter again it was started about a couple of years ago. The faculty is now, I think, new, about just 2.5-3 years old. The faculty as it exists in this university has got a great advantage. There is a treasure of resources around the campus, and if the faculty can utilize these resources, because we are all around. I've even said that, see, the judges also can now and then come and deliver lectures to share their experiences, and for the law faculty students and all, the department should be able to utilize our resources in this manner. We are all there willing to volunteer to share our knowledge, whatever little that we have learned, even to our future students, because it is, we also have a sense of responsibility that this knowledge, what we have, should be disseminated to the next generations. So, just across the road, you have many of the judges, retired and sitting judges in Raintree and so many other places. We are all there. The campus faculty, if they can utilize our services, we are more than happy to come and lecture to you all. So in fact, for the last 2-3 years, I have been waiting even for that kind of an occasion. Let us not turn in these law colleges into those traditional concepts of lecturing alone by the professors. We have something little more to share. Professors do definitely have absolute knowledge, no doubt about it. But then we are also dealing on the practical side, what the law is and how it can be applied. So that knowledge will certainly help the university students who are now pursuing their law courses. If you see the Madras Law College, Bombay Law College, they are all very close to the High Court. And the judges on a very regular basis used to go and lecture. Why I am saying this is the best of the products have come out of Madras Law College, Bombay, Delhi also, Delhi campus. Delhi High Court judges go and lecture there on a regular basis. At least once or twice a week they have one lecture by the sitting judge or a retired judge. Justice Satyanarayana Murthy Garu is also here. He would also be more than happy to come and deliver lectures, share his experiences, vast experience of knowledge, legal knowledge that he has with you all. But that occasion and to create that atmosphere, it all depends on the law faculty. So, wish you all the best. Jai Hind.